Human Rights Practitioner Series, co-sponsored by the International Human Rights Clinic, the Center for International Comparative Law, the Keenan Institute, the Franklin Institute, as well as the Duke International Law Society and the Human Rights Law Society. So thanks to everyone for coming. We're very excited to have Moritz here. He is a visiting scholar this semester and is finishing his PhD looking directly at this issue. So while there's been a lot of attention in the last year on the refugee crisis in Europe, it's certainly not new to Europe. And so Moritz will talk through how the supranational courts, so the European Court of Human Rights and the Court of Justice of the Council of Europe, have addressed these cases over the years. So without more, I'd like to introduce Moritz Baumgärtel.
Yes, thank you, Sarah, very much for the kind introductory words and also all the wonderful organizational work that you have done. And thank you all for being here. Having such a high turnout is really fantastic. When I announced the title of my presentation to Sarah, I made sure that it was sufficiently broad and actually even broader than my research topic, so that I could also refer to more recent events or news items. And this is very, very easy these days. Just this morning, when I woke up, what I saw in the news was that in France, the French government started cracking down on a refugee camp close to Calais, in which migrants from different countries were waiting to seize the right opportunity to get across the channel to the United Kingdom. Now, this camp, which is also referred to as the jungle, and there's over 3,000 people living there, according to some estimates, has been there for many years, and it's, however, been only today and in the framework of the refugee crisis that France took measures to do something about it, and this, on top of that, in a very restrictive manner, as a matter of fact. And this actually gets me to my first point already, which is the fact that referring to something as the European refugee crisis, I do not find this to be a particularly helpful label, and many of my colleagues working on the subject in Europe also do not very much agree with it. This is not to say that it is not a very serious issue with grave humanitarian questions attached, or that it's not politically complex to be addressed. Rather, using the word crisis tempts us perhaps to ignore the context in which these current events are taking place. So, for example, if Europe is confronted with a refugee crisis, what exactly are countries like Jordan, Lebanon, and Turkey experiencing if they are hosting 4 times as many refugees while having much more limited resources and being much smaller in size? Speaking of a crisis might also tempt us to think that there's something sudden or temporary to the problem, which equally is not true. The Calais refugee camp has been there for many years. It's maybe not the right moment to talk about the history of thought and social mobilization about the issue, which would be another talk. But I wanted just to give you 2 graphs which might illustrate this point that the problem is actually entering its 4th decade by now. So each of these graphs show the time of foundation of NGOs which belong to an NGO network, and on the left side it's the European Council on Refugees and Exiles, which is, as the name suggests, mostly concerned with refugee questions. And on the right side you see PICUM, which is an umbrella NGO comprised of organizations that deal with irregular migration and undocumented migrants. And as you can see, it is really throughout the 1980s and the 1990s where civil society starts to become worried and concerned about migrant rights and starts to propose more humane solutions to the problem, as well as, I think, more sustainable solution in many ways. The 1990s are also the time when there are the Balkan Wars, in which, due to which the numbers of refugees arriving in Western Europe is actually very comparable to what is happening today with Syria. So talks of a crisis are at least misleading, I would suggest. Now, understanding this might be valuable in and of itself, but it also relates more concretely to the point of my presentation and the focus of my presentation, which are the European courts. So as a side note, and Sarah already mentioned this, when I talk about the European courts, I talk on the one hand about the Court of Justice of the European Union in Luxembourg and about the European Court of Human Rights in Strasbourg. And I do not want to get into the details about the mandate and their structure, some or maybe all of which might be familiar to you. But just for the sake of completeness, I want to say that these are two distinct and independent courts. And one of them has jurisdiction over matters concerning the European Union with its 28 member states, and the other one has been established within the framework of the Council of Europe, which is larger and consists of 47 member states. There are also other aspects which distinguish the two courts, evidently, but very crucially, they both issue legally binding decisions and have therefore become supreme courts for the continent of sorts, at least regarding questions such as human rights and the EU's fundamental freedoms of goods, services, movement, and capital. So if we accepted the premise that there was a sudden refugee crisis in Europe, we might be maybe surprised to see that the issue has emerged frequently in the last 10 years before the two European courts. And there are two more graphs that I want to show you here. On the left, you see the increase in numbers of cases before the European Court of Human Rights against the backdrop of the overall rise of human rights claims, so that you can compare here. And on the right side, you see the rise in preliminary reference to the Court of Justice. And both of these graphs actually only show asylum cases. So I'm not even talking about family reunification, which is another huge issue with regards to migrants and their rights. So there's enough case law, European case law, for me to write an entire dissertation about it. And actually, I have in my research to focus on a couple of key rulings, because what I'm trying to do is to trace empirically the impact that they have had on migration policy and social mobilization. So as far as the European courts are concerned, there has been an obvious and permanent migration crisis, refugee crisis, for at least 10 years. And looking at some of the policy responses that European leaders are coming up with these days, I think it's safe to say that it will be a crisis for the next 10 years to come as well. So this is the background against which I want to address this question, which is, I think, a very pertinent one. What is the role of the European courts in addressing this permanent refugee crisis? And one could provide a normative answer to this question, but what I'm trying to do in my research and also in this presentation is to approach it a little bit more empirically. And even there, it is not easy to formulate an answer because, as I already said, there are so many cases that can and that should, frankly, be looked at and considered. So just to be on safe ground, I will approach the question from three angles instead of only one. And I know it's a human rights practitioner seminar, but I am so hopelessly academic that I cannot provide one practical answer to this question. I'm sorry. The three answers are grounded in the perspective of different actors, namely states, the issue constituency, as I call it, and thirdly, the courts themselves, of course. Let me address them one by one. The easiest one to cover is probably the role that is envisioned for the courts by Europe's states. In my view, states, and especially their governments, understand the court to have a limited role and to perform, if at all, a sort of corrective function. And from a theoretical point of view, this might not be particularly surprising to you. For those who have an interest in international relations, we might describe this as the point of view that a principal has over their agent, and when they try to retain ultimate authority over the international plane, including in international law. And in terms perhaps more familiar to us lawyers, we could say that in international law, states are still being thought as the Herren der Verträge, the masters of the treaty. Two qualifications, I think, are in order here. Firstly, that states hold such a viewpoint doesn't necessarily mean that it very accurately describes their relationship to international courts, especially if we are dealing with two such highly authoritative courts as the two European courts. And secondly, I do not want to suggest that states always hold such a viewpoint with regards to all policy domains. Actually, I do think that immigration is maybe not atypical, but is a very striking example of a field where they hold this opinion very strongly. So state submissions to the European Court of Human Rights are never formulated in anything that closely resembles apologetic manner, although we are dealing with Article 3 claims here under the Convention, so they relate to the prohibition of torture and inhumane and degrading treatment. Actually, most state submissions start by just dismissing, rejecting the admissibility of a case altogether. And while this may be normal, I do think that it reflects that states try to limit the court's say in these matters. And this is only one of the strategies that they employ. And other things that I encountered in my interviews when I was talking to persons working on the issue in the field was that states actively mobilize each other for third-party interventions before both of the courts when they are confronted with what they think could be an important precedent in case. So one interesting example to be mentioned here is the case of Ramsey, where the UK actually used its presidency of the Council of the EU, which is not the European Court of Human Rights body, so the other European body, in order to inform other governments that actually this would be a good opportunity to revisit an earlier ruling, which is Shahal, where the European Court of Human Rights had held that even if an asylum seeker was a terrorist suspect, one still could not return him or her to a country where there would be a danger of an Article 3 violation. And indeed, Lithuania, Portugal, and Slovakia followed this advice and filed a submission. In the end, the case eventually got struck off the list because the lawyers had lost touch with their clients, so it didn't avail too much in this particular instance. Actually, when talking about cases that are struck off the list, usually governments very actively try to have cases struck off the list. For example, by providing a residence permit to an applicant whose legal status has before been in doubt, or where they before didn't want to have him or her to have a residence permit, just to have the case struck off the list. Now, these are all permissible measures and strategies, don't get me wrong, but I do think that they reflect the general view among states that immigration is a very politically sensitive matter, and that the European courts should deal with it as little as possible. The impact of this ruling should therefore be contained wherever cases emerge. And apart from closing the courts or stripping them of the jurisdiction, none of which are even remotely feasible as options, states can and will try all the other measures. Evidently, states are not unitary actors, and especially domestic courts play a very important role in the whole story, especially because they have the opportunity to refer a so-called preliminary question to the European Court of Justice. As you might know, and this is maybe more detailed on how the court functions, through this procedure, domestic courts refer a case to the European Court of Justice in Luxembourg in order to have the court give interpretative guidance on a question of EU law, so that the domestic court can after that continue with its national proceedings on this basis. But it's really difficult to track a pattern here, how a more general pattern, because domestic courts of different countries, of course, inhibit very different constitutional settings and legal cultures. So interaction will also differ sometimes within one country. To give you an example, in the Zambrano case, it was the Employment Tribunal of Brussels which referred a preliminary reference to the Court of Justice. It was a case that concerned a Colombian father who had an exceptional leave to remain in Belgium, but who claimed a more permanent residency status on the ground that his children, who had been born in Belgium, had by now acquired Belgian nationality due to the country's jus soli laws. And he also asked retrospectively for unemployment benefits, on the same basis. And this turned out to be a very crucial detail because in this case it was the employment tribunal which got to deal with the case and not the Aliens Litigation Council, which would have usually been the body to look at this if there would not have been an unemployment benefit issue here. So there one can see how little details can make a difference as to whether a court arrives at the European level or not. In the Netherlands, the Dutch Council of State, the court's supreme administrative body, is known to be a body that sides often with the government and who is not particularly amenable to arguments that go against the government, even if they're based on European and international law, very much contrary to to the lower courts. So there's a difference here as well. At the end, and this is an observation that I cannot really conclusively prove, but it's an observation I've made throughout my research, domestic courts seem to be more favorable to have the European courts involved, the weaker their own authority is vis-à-vis other courts in the same country, and the more politically controversial a certain case, actually because they then could be quite happy with passing the buck to the European level and not having facing backlash themselves in pronouncing themselves on immigration matters. So if the expectations of domestic courts are hard to trace and perhaps not consistent, I can draw a much clearer picture about the role that is envisioned for the European courts by civil society organizations, by defense lawyers, and also by certain international organizations. In my research, I refer to these as the issue constituency in order to draw a conceptual counterpoint to literature that more commonly refers to constituencies such as mandate providers, so governments, administrations, and diplomats. So remember the graphs I showed in the very beginning of the presentation about the rise in organizations. I do think it's with these kind of organizations, with the creation of these kind of organizations, that migrant rights really started to become a visible item on the political agenda in Europe, and therefore, over time, also a matter for the European courts to consider. In the early cases, before the Strasbourg court, lawyers usually acted individually to bring the case, but nowadays efforts are much more coordinated. So the European Council on Refugees and Exiles, ECRE, maintains a network of immigration lawyers across different countries with various national branches in order to keep the local lawyers, informed about what is happening on the European level especially. Other NGOs such as the AIR Centre in London or the International Commission of Jurists are even specialized in strategic litigation, so they bring test cases before domestic and European courts, and they file third-party interventions wherever they have the opportunity, which is usually easier in Strasbourg than in Luxembourg, but I will come to that in a moment. I'm aware that I'm speaking in the US here, so strategic litigation is nothing groundbreaking here at all. But in Europe, it is a recent phenomenon, and therefore, as such, it changes things. For one, it influences the way in which we might see the judiciary by changing this perception even ever so slightly. And the courts can possibly emerge as the guardians of human rights in this scenario, and possibly also as a counterweight to more repressive migration policies. And more crucially, the members of this issue constituency continue bringing new legal arguments, innovative legal arguments, and new sets of facts to the courts. So thereby pushing their reasoning and, well, over a number of cases, perhaps even changing their substantive viewpoint. Let me give you an example at this point, very specifically concerning the European Union's Dublin regulation, and you might be familiar with it. But just to say a few words about it, it allocates responsibility within the European Union to states to deal with a certain asylum claim. So the idea is to prevent forum shopping in the sense that an asylum seeker would usually go to the country where he would have the most favorable asylum procedures and the most generous reception conditions. And there are a number of grounds in which states incur responsibility, but the key point of the regulation is that most most claims will be dealt with by the so-called countries of first entry, where so a refugee enters on the territory of the European Union, which is usually Greece, Italy, Spain, and Malta. And therefore, the regulation is quite controversial because it disproportionately burdens these states with dealing with the refugee question. In the case of Greece, over the years, it has led to an almost complete deterioration in reception conditions and in the asylum procedure. So by the end of the 2000s, we have a situation which has become so dire that we have a lot of cases emerging before the European Court of Human Rights. And the applicants there are claiming that they are being subjected to inhumane and degrading treatment because they are either sleeping in detention centers where they cannot even lie down on the ground, or they're sleeping rough, or just the asylum procedures are so inadequate that only 1% of people from countries like Afghanistan or Iraq will actually receive asylum, which is totally not realistic, and therefore contrary to the convention. But importantly, these claims are not only being filed against Greece, but they're also being filed against countries like Belgium or the United Kingdom, because they are returning them, the asylum seekers, to Greece under the Dublin regulation. In the beginning, the European Court's approach, the European Court of Human Rights' approach, is not very encouraging, to say the least. So in KRS, the first case here, the court decides that the applicant should really bring a case not against the UK but against Greece if he has a problem there. And in any case, the United Kingdom could expect Greece to abide by its obligations under international law, including human rights obligations under the European Convention. So that's a decision from December 2008. Only 2 years later, in MSS, the court takes completely the opposite viewpoint. It sustains the Article 3 claim. It says that reception conditions in Greece are not appropriate, and neither is the asylum procedure, which is totally defective. And it also holds Belgium responsible for actually sending the asylum seeker, in this case an Afghani asylum seeker, back to this situation. What had changed? Now, obviously, it was the Grand Chamber which was in charge of this case here. Which implies that the court took the issue more seriously and gave it more thorough consideration. But that still doesn't answer why it received renewed attention in the first place and why it was not declared inadmissible, essentially for res judicata reasons. There's a couple of reasons why this did not occur. Firstly, the lawyer in the case acted very strategically in bringing a case both against Belgium and against Greece, and thereby preventing the same reasoning as in KRS to apply. Another important point was that new evidence of bad practice in Greece had emerged in the form of a letter, most notably that the United Nations High Commissioner for Refugees had sent to the Belgian authorities, and where he had explicitly advised Belgium against returning people to Greece. And this received a lot of attention also in the reasoning of the court in MSS. During the hearing and in the submissions, there were also a large number of third-party interveners from the issue constituency, including Amnesty International, the AIR Center, the Council of Europe Commissioner on Human Rights, the UNHCR, and the Greek Helsinki Monitor, so really quite a list. And they pointed out, firstly, they point to a lot of evidence that the situation in Greece was unacceptable, and also they, for example, argued that the Belgian authorities themselves had used the same documents they were relying on already in their internal procedures. So they could and should have known about the situation, should not have returned the person. But efforts of the issue constituency were not limited to the Strasbourg court alone. So around the same time, there's also the case of NS-NME, which is before the European Court of Justice, and which was a case that involved the United Kingdom and Ireland, both of these countries. Again, it was Amnesty International and the AIR Center who not only filed third-party submissions, but they were also involved in the strategic planning of the case together with the lawyers of Doughty Street Chambers in London, which is a set of human rights lawyers which is very resourceful and very strategically oriented. And together they filed 2 claims, one in the UK and one in Ireland, also again in the hope of having them combined once they reach the European level. And also in order to prevent the courts dismissing the UK claim, because at the beginning of the case there was a question whether the fact that the UK had signed a protocol to the Charter of Fundamental Rights of the European Union made that very same charter not directly applicable in the country. In the end, it turned out to be applicable. In the beginning, this was not yet obvious. So the ruling in MSS came out first, and then the lawyers in NS kind of adapted, and they tried to base their submissions on other articles other than Article 3 or Article 4 of the Charter of Fundamental Rights about the prohibition of inhumane and degrading treatment. So they were relying, for instance, on the right to asylum. In order to give the case additional value and to even strengthen the standpoint that under human rights, European human rights standards, the returns to Greece under the Dublin regulation were a violation. And the court in the end did limit itself to Article 4 of the Charter, but still the fact that the Dublin regulation came under fire within the same system from which it originated, namely EU law, it was quite a big deal for us in Europe. And the story actually doesn't stop here. I do not have enough time to discuss the Tarakel case, in which that was end of 2014, in which it was not Greece but Italy which came to be the subject of the case. And it was again a case before the Grand Chamber of the European Court of Human Rights, and many of the organizations I mentioned before were again present, again filing submissions and so on. And eventually the court did hold that the Swiss authorities had to get diplomatic assurances from the Italians before actually returning an Afghani family with 6 children to Italy, because it was not, they could not expect that they would be accommodated properly. So they had to get diplomatic assurances at least. Now, all of these cases have not fixed a lot of bad things, such as the Greek asylum procedure and the reception conditions. Now, the reception conditions have been only this month again been declared unacceptable in convention terms by the courts in Amadou, which is the last case here on the slide. But I want to point out that from the perspective of at least parts of the issue constituency, the 2 courts emerged as really valuable tools for promoting change and perhaps even systematic change when it comes to the rights of migrants and asylum seekers and refugees. This finally gets me to the last type of actors. Let me disappear before I run dry. Which are the 2 courts themselves, of course. Up until this point, you could say that the story that I'm presenting here is a very classical example of the counter-majoritarian dilemma in a sense, and that's certainly correct. But what the judicial branches can and actually will do about such a dilemma is not something that the theory is always very clear about. But I'll try to do this at this point very specifically with regards to the 2 European courts and refugee rights. Though, mind you, the empirical basis for my observations are, of course, the decisions and the reasoning, as well as some interviews. So in a sense, it is limited in the sense that we cannot get into the heads of what judges really think. So first, the European Court of Human Rights. Traditionally, and I would say even in most cases today, the court has accepted the role that is envisioned to it by the states. So its default position is that states have the right to police their borders, and they have so, and I quote here, they have this as a matter of a well-established principle of international law that the court routinely invokes in its reasoning, that cannot easily be defended by human rights arguments. So this implicates, on the one hand, that a lot of cases will be declared inadmissible because they just fall within the state's discretion to do certain things, and they're probably manifestly unfounded. And on the other hand, even where they do reach the courts, the applicants and their lawyers still have to face an uphill battle, also in terms of defeating this assumption that states have the discretion to take measures. Now, I cannot claim credit for this observation, but I have to refer you here to a really excellent book by Marie-Bénédicte Dembourg from the University of Brighton, who has made this conclusion on the basis of really a very detailed analysis of even the earliest case law of the European Court of Human Rights. And by the way, I can recommend this book to anyone who is interested in migrant rights, because she doesn't only talk about the European Court of Human Rights, but also about the Inter-American Court of Human Rights, which she argues has a more human rights first approach, as she calls it. So that's very interesting. So to give you an example of the Strasbourg Court's rather restrictive attitude, we may look at cases of persons who are not individually being persecuted, so they don't fall within the classic definition of the refugee of the the Geneva Convention on Refugees, but who are trying who seek international protection from generalized, high degrees of generalized violence in countries like Iraq, Somalia, and most recently, of course, Syria. And the first time the court was confronted with this question, it was in 1991, it rejected this claim that one could get protection under the convention in such a situation, because, and I quote here, the situation was not any worse than the generality of other members of the Tamil community or other young Tamils who were returning to their country, so Sri Lanka. And this precedent stood for over 15 years, blocking in particular the very strategically acting UK lawyers who very badly tried to challenge the practice in the UK of returning persons to such a situation. Now, the situation gets the case gets very interesting here, because in Salashek, which was a case that involved a Somali applicant and the Netherlands as a country, it was another section of the same court which was in charge of dealing with this claim. So just to clarify, the European Court of Human Rights is divided in different sections, and claims from the same country always arrive at the same section of the court, which is therefore in charge of a number of countries, but it's always the same countries. And the Dutch section of the European Court of Human Rights decided that there would be a violation of, in case of expulsion to Somalia, because the applicant belonged to a vulnerable minority in the country and had therefore not to prove that he was personally targeted. So this might seem like only a small change in the reasoning of the court, but it really brought some movement into the whole story, and eventually also the UK section had to revise its stance in Sufi and Elmi, because it couldn't declare the cases inadmissible anymore. And there it held that returning a person to Mogadishu was unacceptable because of the high degrees of general violence there. So that was in 2011. Now in 2013, finally, in KAB, the court moved back to its old stance, at least with regards to Somalia and Mogadishu, which it now deemed safe. And this has been its last word until now. I find this chain of cases very interesting and really quite exemplary of what the role that the European Court of Human Rights is playing. By default, it takes a quite lenient stance towards states and their migration policies, which can, but it doesn't do exclusively so. So a number of judges in the court will hold a very different opinion on the same matter, and this is also reflected in the dissenting opinions in many migration cases. And if the time and the case is right, the European Court may well intervene and might do so when it does in quite a forceful way. But that's not where the story ends, because afterwards more cases of similar facts or slightly different facts will be launched, and the European Court will be faced with the question of how to integrate the very assertive judgment with its earlier deferential rulings, leading to a sort of a back and forth approach, which I think in itself actually also decreases the influence that the court has in human rights questions, and which therefore increases the discretion that states enjoy to implement the policies they desire. So let's use this observation to compare it to the European Court of Justice and its potential role. So firstly, The Court of Justice has become involved more recently, and therefore its case law is less extensive. Also, asylum seekers cannot petition the court directly. They have to go through the already mentioned preliminary ruling procedure, which also decreases the caseload on the court, and therefore gives it much less opportunities to actually pronounce itself on migrant rights questions. Also, third-party interventions are only permissible in Luxembourg when you have already been part to the proceedings at the national level. So this is much more difficult it's therefore much more difficult to be a third party in Vienna because you don't necessarily know at the national level whether a case will reach the European level or not. There are also no dissenting opinions, so judges have to come up with something consensual, which usually leads to general and sometimes quite vague judgments. And finally, Luxembourg is not a human rights tribunal, but it is a general court with the primary objective to interpret European Union law and to strengthen the EU's legal order. And all of this would speak against the court, and does speak against the court taking a more proactive role than the European Court of Human Rights. But there's another key difference, and this is that in the early 2000s, European states devised a number of instruments under EU law to establish what they called the common European asylum and migration policy. And I already mentioned the Dublin regulation, which is part of this framework. But there are also other directives, such as which deal with qualification for protection, reception conditions, family reunification, long-term residence, and returns. And of course, all these instruments include both restrictive and protective elements. But what is important here is that they provide a very clear jurisdictional basis for the European Court of Justice to pronounce itself on migration issues. So, compared to the European Court of Human Rights, the Court of Justice in Luxembourg doesn't have any particular reason to take a generally deferential approach to the whole matter, where cases do appear, even if that is more rarely the case. And it's also the impression that I got from talking to the lawyers in the field, because they see the European Court of Justice as a very promising opportunity. And I think that's also because, to some extent at this point, the European Court of Human Rights has somehow missed its chance to establish itself as more than just the occasional defender of migrant rights. Now, one last example, and I unfortunately do not have the time to discuss as carefully as I would like this very interesting and very complex question, which concerns two cases of LGBTI asylum seekers, so persons who are fearing persecution in their home countries because of their sexual orientation. And only about 10 to 5 years ago, Europe's states were not particularly receptive to this claim, and they argued that, well, they should just exercise restraint and discretion in the way they go about their daily lives in their home country and thereby avoid persecution. Now, clearly, there's a huge human rights issue here because we are talking here about criminalization, criminal charges, including imprisonment of many years, and in the worst case, execution. So legislatives and judiciaries across Europe actually started to become more considerate of the arguments with regards to LGBTI asylum seekers in the last 5 to 10 years. And the two cases that I mentioned here are the Court of Justice's contribution to the whole debate. Both cases originated in the Netherlands, which is not surprising because there you have a very strong both academic and civil society support for the cause. And I cannot go into long details about the judgment, but the Court of Justice decided, for instance, that this discretion and restraints requirement were clearly not in accordance with the EU's fundamental rights principles. States also could not rely on intrusive questions, videos, picture evidence, or tests, in very big quotation marks, to find out whether a person was truly LGBTI or not. And this was very common in most European states. And to compare once more, the European Court of Human Rights actually throughout the years has never gone that far and has been even itself dismissive of applicants questioning their credibility and whether they were truly LGBTI. But even the Court of Justice doesn't go all the way. So it says, for example, that criminalization alone does not suffice to claim a fear of persecution, but that the criminal laws in the country of origin actually had to be enforced. It also says that declarations of one's sexual orientation were not sufficient to prove it. So states could devise some sort of tests, questionnaires, or whatever to find out about the credibility, which raises a big question because nobody really knows how to do this in a human rights abiding manner, and the Court of Justice doesn't provide any guidance regarding this question either. So the fact that the Court of Justice, in an area where human rights arguments had very clearly gained the momentum across Europe, still has a deferential approach on very central questions, tells us, I think, a lot about its general approach to migrant rights. So is the glass half full or half empty in this regard? I'm an optimist, so I would like to think that these two cases, which were very high profile, still gave LGBTI asylum seekers and the supporting organizations the opportunity to raise awareness of what is happening and to even change some very important parts of what used to be very restrictive and very problematic policy. So they achieved some progress. But despite that, I don't think that the courts really did the heavy lifting in this regard and went all the way through to really push states even further in a human rights direction, which they had already taken. Let me stop at this skeptical note, which is also the one that I have more or less in my dissertation. And I hope that I could give you an overview of the state of affairs in Europe, and so that you can also make up your own mind on what the role of the European Court is at the moment. I'd actually be very interested to hear that from you and also to answer any questions that you might have. Thank you.
Maybe take some questions? Take a seat. So I definitely have some questions. But I figure I'll open it up to, and if you could say your name and your year. If anyone has any questions?
I'll start. Hi, I'm Jane Hutter, DI Director of the Human Rights Clinic here at Duke at the law school. And my question is exactly about what you began to touch upon, which is the interaction between your supranational courts and your supranational political bodies, right? Because in Europe, I mean, the types of laws at which we're speaking are not totally state-driven. I mean, they're within the broader framework of directives and EU law and so forth. And so you began to talk about the European Court. Can you talk a bit about the European Court of Human Rights and how the court does or does not find a way to talk to and address these broader, not state-based policies?
The European Court of Human Rights in particular. Mm-hmm. Yeah, I mean, this was also part of the main issue, for example, in the Dublin cases, where the question is whether, because the Dublin regulation establishes a sort of an assumption also that states will deal with the question, with asylum applications in a human rights respecting way. And this is, of course, therefore part of EU law. So what happens when the European Court of Human Rights pronounces itself on the question is that it challenges, to a large extent, even this assumption. And this is one of the major differences also in the reasoning in these two cases, where the outcome is very similar, but the reasoning is a little different. Now, with regards to the Dublin case in particular, there's this small little humanitarian clause, as it is called, according to which a state can still accept responsibility to deal with an asylum seeker, an asylum claim, even if under the Dublin regulation it should go somewhere else. And both of the courts have used this little backdoor to say, well, look, I mean, we are not actually touching upon the Dublin regulation.
Yeah.
I'm Tess, I'm an international analyst. I have a question about, you mentioned that one of the issues in Greece is that people from certain nationalities, like very few of them are getting accepted as refugees. And I've read elsewhere that there is this kind of inconsistency between countries of first reception and how they interpret what a refugee is and how maybe other countries use that definition. So I wondered if that issue had been talked about in the European courts, do they have jurisdiction to kind of think about the inconsistency of application of the refugee definition, or is that precluded by marginal appreciation? How does that work?
So by now this clearly falls within European Union law, because there's the qualification directive on this question, which provides a clear refugee definition. Not only that, it also provides a definition of who is eligible for subsidiary protection, so it's a kind of complementary protection for example, persons who are fleeing from generalized violence. So actually, this should kind of even out the way in which this is applied. Now, it does not, of course, get rid of all the differences between the states, but as regards to second questions in particular, yes, there's a clear jurisdictional basis for the European Court of Justice to pronounce itself on whether a person should be a refugee or not. I mean, I think the case on generalized violence, and I did mention the Luxembourg case here, which is El Ghafaji, where the court also dealt with essentially the same questions. There it pronounced itself, for instance, on the qualifications directive. It also did so with regards, for example, to whether a person would be eligible for protection if he or she was being targeted by a non-state actor. So the Court of Justice has come in on a number of occasions to talk about this, but maybe not essentially about the refugee. I mean, the last bit is on the refugee definition, but it's also quite well-established principle, so states usually know what a refugee is supposed to be.
My name's Greg, undergraduate senior. You spoke at length about, I guess, the history of the courts, I'd say for the last 5 or 10 years. Based on how they've evolved over time, how would you say, or where do you see it evolving, I say, for the next 5 or 10 years, as the migrant crisis probably continues to exacerbate itself?
No, you make me predict things. Don't do that. No, seriousness. Well, so as you could hear maybe from my skeptical conclusion, for example, I do not think that the European Court of Human Rights is going to turn more into a more assertive body, especially now that the question is even more politically sensitive than it was before. Because it has made quite clear that it's not very happy to address these questions. I do think the Court of Justice is different because the jurisdictional basis is so clear and more recent. And the Court of Justice can always say, well, it's only been 10, 15 years that you actually accorded us jurisdiction in this regard, and now you're unhappy with what we're saying. This doesn't make much sense. But again, I do not think that the Court of Justice is particularly happy to invest its political capital there. Even leaders in Europe are not happy to do that and to really go more towards the side of migrant rights, because essentially it's also not people that are voting. Now, this doesn't influence the courts, but the political climate is one in which the things are getting rather worse than better, despite of the fact that there's an issue constituency, which is very vocal and which is trying, but at the moment it's really stemming a tide. So my conclusion would not be particularly optimistic in this regard on future developments.
Can I ask a related question, and I'm slightly asking you to predict as well? If you were, involved, a member of the issue constituency, one of the organizations, given what's going on, what do you think is the next strategic litigation kind of issue or case you think they're looking to take on?
I mean, a lot of these things, as I said, there has been a kind of consistency in this being issues in the past, and they continue to be issues. I mean, the whole Dublin regulation question now turns into a question of how to reallocate migrants, perhaps. So one of the striking questions here is, even if you have schemes according to which refugees which are recognized are distributed within the European Union, why exactly should refugee XY go to a country like Slovakia? And on what basis do you force him to do this? So this is also a question that raises questions on human rights. And I don't know if I would bring a case. I'm not a human rights lawyer, but it could be something that we would see emerging. So this would be only with regards to the Dublin regulation. But of course, reception conditions, the things that you see on the TV about people being pushed back at the borders, All of these things raise human rights concerns, but it remains to be seen how exactly and when exactly they appear. I would like to answer something on that.
Yes.
Hi, I'm Megan Morris, I'm also an undergraduate senior. So you said that the sort of outlook for litigation in these courts isn't necessarily a good one. Do you think that this route, like through litigation through these courts, is the best route to tackle this issue, or are there other ways that you might recommend looking at it, or maybe in conjunction with mediation?
I posed the same question to many of the interviewees that I had, and I mean the answer is somehow lies at hand. It cannot be the only way. I mean, political mobilization is perhaps even more important. But here, I mean, the courts can come in also, because once you have a decision, you have a tool to mobilize people. You can say, look, this particular state practice has been completely contrary to human rights standards, and we really need to do something about this. The politicians need to do something about this, and so on and so forth. And actually, very interestingly, states therefore often try to slightly adjust their policies before a decision comes out to be able to respond, yeah, that's true, but we have already done that. So thereby also reducing the impact in terms of social mobilization. So I think there is a role even for litigation here for what I think is the more important bit, and I would agree with you probably, which is to somehow get the issue of migrant rights. I think it's visible, but to get more appreciation for it at many different levels in domestic politics and also at European Union level, and frankly at the global level. I mean, things like resettlement of refugees under the UNHCR scheme. 75,000 people were resettled last year. That's you already have that group of people in one refugee camp in Jordan alone. So this is also something that concerns not only Europe, but evidently the UN system and the international community as a whole.
And get back from that question, I mean, you mentioned earlier in your presentation a little about the interaction of the UN High Commissioner for Refugees and the court. Can you talk a bit more about that, the European Court of Human Rights and UNHCR or other UN agencies? Like, how do they interact, if at all, in practice?
I think it's probably safest to focus on UNHCR here, because it has what my impression is it has a very privileged role. So if we take the case of MSS, for example, this letter by the High Commissioner about the changing practices in Greece, and that Belgium should therefore have known, features so prominently in that reasoning that one cannot but conclude that, well, this is where the court is taking the political credit in order to place itself in its own human rights protecting decision on. So it has a privileged role, particularly as evidence, but it's also, I mean, the UNHCR also itself is very active in fighting third-party interventions, for example. There have been suggestions in scholarship from people working for the UNHCR, but I actually am quite, I agree with them that the UNHCR should also get a more privileged status in front of the Court of Justice, so kind of be dispensed of this requirement of being already part of the national proceedings in order to file a third-party intervention. I think this would generally be a good thing, not only with regards to migrant rights, but essentially you have the UN organization dealing with the question, present in the courtroom and in the submissions and giving its opinion, and that this can, any person somehow interested in the quality of proceedings can only agree with. I should agree with this.
I can ask, if I understood you correctly, there's some areas, particularly with like LGBT rights, where the Court of Justice has actually gone further in terms of human rights than the European Court of Human Rights, which, I mean, is a bit counterintuitive and was a bit surprising. Why do you think? I mean, are there certain actors or states that are more influential in at these different fora, or why do you think, in some issues that the Court of Justice has actually been more progressive?
So with regards to this example in particular, I do not think that it is necessarily because of the state involved here, which is the Netherlands, which is also part in many European Court of Human Rights proceedings. And actually, it's a very, very good question why the outcome is so different. Essentially, the question really is, why has the European Court of Human Rights been that dismissive of LGBTI asylum seekers? And it's really, really difficult to find a good answer for this. I mean, somehow it appears when you look at the cases that maybe they didn't find the facts to be too appealing, maybe they would have pronounced themselves if the case would have been more compelling, but generally the reasoning is just so meager and so, just questioning the credibility of a person basically pursuing the same restrictive policy the states have been pursuing it's very hard to understand for a specialized human rights body. So I don't really have an answer for this, and in scholarship also this is actually being talked to very little, so I couldn't find answers even that. But as I said, the Court of Justice has a very clear jurisdictional basis, so maybe it has less fear of addressing certain questions, and this clearly fell within the qualifications directive and about refugee question, the definition of a refugee, and these issues. So I think it was the court was very thankful to get a case like this where it clearly pronounced itself.
Well, thank you so much. I've really learned a lot about the European courts, and thank you so much for coming today. Before everyone leaves, I just want to do a plug for, as we said, this is an ongoing human rights practitioner series. Tomorrow we're going to have another speaker, Stephen Watt, the senior staff attorney with the ACLU, will talk about legal challenges to the CIA torture program, and specifically a case that was brought against the psychologists who designed and implemented the torture program. So if you're around for lunch, it'll be the same tomorrow. Thank you. Really interesting.
Thank you. Always worried if it gets too technical, because it's very technical.
Well, I think, as you probably saw, they're still quite new and familiar with the new system. That's why I thought it was really good. Strategic litigation. U.S. senators are very familiar with the idea that this is actually relatively new.
Yeah. I tried to do it as possible.
I have a question that I really want to ask everybody. I'm a teacher for a middle school student again, much later.
Thank you.
And so the students are have the healing HCR committee. But I have a question about the legality of some of the actions, the threats of wall, or today I read about Macedonia spraying tear gas. So I don't understand, how does that, is that legal? Not legal? I'm not a student in law, but I was curious to know about how that plays into things.
The thing firstly to say, recent events, it always takes a long time to arrive at a court. So if things happen today in Macedonia, and they have been happening, I know, for at least last summer, and Hungary has closed their borders and put the fire again. But it takes time to go then first into the domestic journalists and so on. Now about the legality of the things, it's actually a very difficult question about border control being because. Yes, it's first a jurisdiction question. Is it really already within the jurisdiction? Yes, it's kind of, you target people, you put the wall, but then is it really disproportionate towards the objective of policing the borders? And it's not my personal view, but as you saw from my presentation, they have the right to police the borders.
Yeah, that's why it's complicated. Okay.
It's very complicated and it's frustrating sometimes. And it's not a panacea in this sense at all, especially when you are constantly confronted with new restrictive policies. Because every time you come again, I can't be too optimistic on these things. It's terrible. Don't shoot the messenger.
I was curious about how it played out.
But it might arrive at the court eventually, and it might...
Eventually, right? Yeah. Okay. All right, well, thank you very much. Bye-bye.
again.
Yes, thank you so much actually for making this possible. It's really nice of you.
And then Ali will send you once it's online the link, so there'll be a direct